Another rift between state governments and governors has emerged in Tamil Nadu as well as in Kerala, and this time once again the rift has reached the Supreme Court. The Tamil Nadu government has approached the Supreme Court against Governor R N Ravi for what it calls a constitutional deadlock. It says that it blames the governor for creating a constitutional deadlock by delaying or even failing to consider and give his assent to crucial bills passed by the legislature. The government says that the governor's actions are hampering day-to-day governance in a way which is threatening to bring the administration in the state to a grinding halt. Similarly, on Thursday, the Kerala government also asked the Supreme Court to direct Governor Arif Mohammed Khan to clear 8 bills passed by the legislature in a timely manner. The petition says that 3 of these bills have been pending before the governor for over 2 years. But this isn't really the first time that a state government has locked horns with the governor in their states. Just recently, Punjab and West Bengal also saw growing tensions with center-appointed governors at crossroads with the elected state governments. So in this video, I'm going to tell you about the governor's powers under the Indian Constitution, especially with reference to their powers to give their assent to a bill. Now, in India, there is no election for a governor, and it is the sole prerogative of the center as to who is to be appointed to the post. The Constitution empowers the governors with various functions, including granting his assent to bills passed by the state legislature, granting pardons, appointing the Advocate General for a state, summoning the House of the state legislature, etc. But the Constitution requires the governor to act on the aid and advice of the Council of Ministers headed by the Chief Minister of the state. He would not need this advice only if the Constitution requires him to carry out any function at its discretion, but this is in exceptional circumstances. Now, when a bill is passed by the state legislature, it has to be sent to the governor. The governor then has 4 options. He can give his assent to the bill, in which case it will become a law. Or second, he can withhold his consent. Third, he can reserve the bill for consideration of the president. Or fourth, he can return the bill for reconsideration of the state legislature. The Constitution also clarifies that when a bill could derogate the powers or endanger the position of the High Court, in such a situation, the governor should reserve the bill for President's consideration. However, if a bill is returned to the legislature and then submitted again to the governor for his assent for a second time, it is mandatory for the governor to grant his assent this time, the second time. While there is no rigid timeline on how long the governor can take while considering a bill, the Supreme Court has offered some insight into this. In fact, it was as recent as in April this year, the Supreme Court asserted that governors of states should either give assent or return bills as soon as possible. This observation was made in a similar stalemate between the state government and the governor, but this time this was in Telangana. The Supreme Court was hearing a plea filed by the state of Telangana seeking directions to the governor in the state to give her assent to 10 key bills passed by the state legislature pending before her. The Supreme Court had asserted that the expression "as soon as possible" used in the Constitution, you can see the provisions on your screen right now, it said that it has significant constitutional content and that constitutional authorities must bear it in mind. In this case, when the case was pending before the Apex Court, the governor in Telangana quickly took action on all the pending bills. So she gave her assent to some bills, referred some others to the president, and said that some of the other bills were under active consideration. Also, just to let you know, since I mentioned earlier that the governor usually has to act on the aid and advice of the Council of Ministers headed by the Chief Minister of the state, except for in exceptional circumstances. So granting assent to a bill under Article 200 of the Constitution also needs to be done based on the aid and advice of the state government, the Council of Ministers. This was in fact clarified by the expert commission set up under former Chief Justice of India, which said that this provision does not give such a discretion to a governor when considering bills passed by the state legislature, but it of course clarified that there may be certain rare exceptional circumstances in which he may act in his discretion. The commission gave examples for this as well. For example, if the provisions of the bill clearly violate fundamental rights or if they go against the framework of the Constitution so as to endanger the sovereignty, unity, and integrity of the nation. Now, the commission had very clearly said that, and I quote, he, that is the governor, should not act contrary to their advice merely because he personally does not like the policy embodied in the bill, unquote. Now, just to let you know, the Tamil Nadu government's petition has said that the governor has positioned himself as a political rival in the state by not assenting to legislation, policies, orders, and other files forwarded for consideration of the governor. It has therefore contended before the Supreme Court that the governor has no discretion to act against their aid and advice except in specified exceptional circumstances, and that Ravi is bound to act on the state's advice in a time-bound manner. The state government has urged the Supreme Court to fix a deadline or an outer time limit for Governor Ravi to consider the bills and government orders pending with his office. So whatever the Supreme Court actually decides in this case, like I mentioned, this issue keeps coming up before the court, or even keeps coming up between the state governments and the governors. So whatever the Supreme Court decides in this case could play a huge role in how the relationship between state governments and governors fare from here on. That's all I have for you for today. This is Apoorva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.